If the prosecution repeatedly announces not ready for trial but fails to give explanations as to why they're not ready, should they be charged with the entire period of time for speedy trial purposes? To find out, you have to read People v. Labate, but it's 39 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases and I try to do it in 5 minutes or less. This is the episode on the case of People v. Labate. The citation for this case is 2024 New York Slip Opinion 01582, published by the New York Court of Appeals on March 21st of 2024. The issue in this case is whether the people, the prosecution, are responsible for the entire adjournment period under a speedy trial statute if they fail to give an explanation for why they're not ready in a post-readiness context. I'll explain all of that in a few moments. To understand and appreciate the context of this case and how it fits in, you have to understand that CPL, Criminal Procedural Law 3030, is the speedy trial statute, and it requires that the prosecution bring a case to trial within a certain amount of time from the commencement of the action, from when the accusatory instrument, either the indictment or the complaint, is filed with the court and arraigned upon. So, and the amount of time for the speedy trial statute is different depending on what level of crime is the defendant is facing. If it's a felony, it's 6 months. If it's an A misdemeanor, it's 90 days. If it's a B misdemeanor, it's 60 days. If it's a violation, it's 30 days. So, for example, for a felony, if the people don't bring the case to trial within 6 months, within 180 days, actually, of the matter being arraigned, then it's subject to dismissal, regardless of the merits, whether the defendant is guilty, not guilty, it's dismissed or subject to a motion to dismiss if they fail to do that. And their people are charged, the prosecution is charged with all the time from the commencement of the action until they announce ready. That's until they file their statement of readiness or their certificate of readiness. And at that point, they're not charged with any time until and unless they say they're not ready. Until they become unready, then they're charged with a time, generally, that they request. If they say, we're not ready today, but we're ready in 7 days, they're charged with the 7 days. There's other exclusions such as court congestion or motion practice. But the delays that are not attributable to them are generally not charged to them in terms of figuring out how much time under the speedy trial is allocated. There's generally a 3-step process with respect to a motion to dismiss under 3030. The first is the defendant has to sufficiently allege the people are not ready within the statutory period. They say it's been more than 180 days and the defendant has not been tried. The burden then flips to the people to show their entitlement to the statutory exclusions. They have to show why there's periods that are told that don't make it a violation of the speedy trial statute. And finally, then the burden flips back to the defense to show that the people's reasons that they're giving are illusory. That's the general process for a motion to dismiss under CPL 3030. What are the facts in this case? The facts are that on December 10th of 2017, Patrick Labate, the defendant in this case, was arrested and charged with reckless driving, VTL 1212. He drove into a police car that was parked, separating 2 different streets. The top charge he's facing is an A misdemeanor, which has 90 days of speedy trial time allowed. He's arraigned the next day, and finally on December 28th, the people file a certificate of readiness, stopping the clock, right? So they're charged with all the time from when he's arraigned until they file a certificate of readiness, which is 17 days. It's set for trial. Ultimately, there's a lot of motion practice. There's things that happen. It's set for trial on September 5th of 2018. At that time, it's the first time out for trial, the people say, we're not ready. We are not ready. They don't give any reason as to why they're not ready. People request 12 days, but because of court congestion, it's adjourned until October 18th, like a month. On October 18th, it's on for trial again. The people are not ready. They don't give a reason again. It's 2 times in a row now. No reason. They request a 9-day adjournment, but because of court congestion, it's adjourned to November 28th, more than a month. People say the court says you have to file a new certificate of readiness. On November 28th, the people are not ready. Again, 3 times in a row. They do not give a reason. They do not request a new date, and ultimately, they file a new certificate of readiness a couple of days later. Finally, it's on for trial. The people say they're ready, and the defense says, wait, you've gone beyond the 90 days, move to dismiss under 3030, speedy trial statute. The judge denies the motion, the defendant's ultimately convicted, and he appeals. And the appellate term unanimously reverses. They say the people's failure to provide any explanation for September, October, November means that they should be charged with the entire period of time, not just the amount of time that they asked for, but the court congestion time too. Okay. for some of those adjournment dates. Goes to the Court of Appeals, and they say, it's a majority in dissent here. The majority says that yes, first of all, the defendant did sufficiently comply with step one. He alleged people were not ready within the 90 days that they were allowed because 420 days had elapsed between his indictment and the date of his 3030 motion. The burden then flipped to the people to explain their post-readiness delay. And at that point, they say the people failed to explain their post-readiness delay. They never explained why they were not ready. Those 3 different times. This is the rule here from this case. The holding is when the people failed to offer a reason for the post-readiness adjournment causing the delay, they are charged with the entire delay, not merely the length of the adjournment that they requested. So instead of them asking for 9 days and only being charged 9 days, even though it's adjourned for a month and a half, they say the people's repeated unexplained unreadiness on repeated trial dates to which they dissented cast grave doubt on any claim that the delay undisputedly was due to court congestion. So they say because of this, they're charged with the entire delay. It does exceed 90 days, case dismissed under 3030. There's a strong dissent saying the majority is changing the rule here. This is a new rule. It's not fair, and they should only be charged with the time that they're asking for. But that's the case of People versus Labate, meaning that if people fail to provide their explanations for why they're not ready after a post-readiness, after they've announced ready, they'll be eating the entire adjournment possibly, not just the amount that they've asked for. That's the case of People versus Labate. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.